All right, we're just going to wait a couple more minutes before we get started. I see some familiar faces in here, which is always nice. Okay, so in honor of respecting everyone's time, especially on a Monday, thank you so much for coming to Level Up Legal's workshop called How to File a Trademark.
Okay, 1 second, sorry, I'm just.
Oh, no worries. A little bit about Level Up Legal. So as some of you may know, we are a women-owned law firm. We focus on business and intellectual property matters, and we help entrepreneurs, startups, content creators, and various businesses to level up and protect their business. Can I actually ask everyone who isn't, oh, I can just mute people myself. This is great.
It's so weird because I don't.
All right, I think I muted everybody. Great. So we're going to kind of walk through the next steps of the workshop, but I do also want to introduce two of my associates. We have Brittany Singh. She is an intellectual property attorney with Level Up, and Selena Portillas, who's been with us previously as an intern, now as an associate, coming on to really lead this workshop. And so during the workshop, we are going to have the chat function open. So I will be monitoring that. And I just wanted to kind of get a gauge of where people are in terms of their trademarks. So I believe you can chat this, but, as a show of hands, I believe, how many of you have filed a trademark? And how many of you are interested in looking to file a trademark? And you can just chat in the chat box, if I could find that anywhere. All right, let's see. Great, looking to file, great. Oh, more people. Great, and so now we're just gonna go ahead and jump into the presentation. And so I believe I'm going to pass it off to Brittany and Selena. And then any questions during the presentation, please feel free to reach out in the chat box and I will be sure to answer them accordingly.
Hi, everyone. I'm Selena. I'll begin. So we're going to start with why is a trademark important? So to begin with, what is a trademark? A trademark is a form of intellectual property. It could be a word, a phrase, a design, your brand name, and it identifies goods and services from a particular source and distinguishes them from others in the marketplace. So why is this important? If you're an entrepreneur and you're starting your business, one of the first steps in the business formation process that we always recommend is to form your legal entity. And then after that, once you start coming up with your brand name and logo, you should register your trademarks because this will help identify your unique goods and services from others, and it provides your business with brand protection. This is especially important if you're in a competitive industry or you know that you're selling similar goods or products from other businesses. Trademarks also help stop competitors from imitating your brand or poaching your customers. It also offers legal recourse to infringers if you are registered, and it can generate licensing opportunities, which can provide valuable source of income and create new revenue streams for your business and help open your business and expand its brand.
Next slide. All right, great.
So how do you obtain a trademark? It's important to note that the whole process of trademarking can be complex and time consuming. So it's recommended to work with an IP attorney throughout this whole process. By working with an attorney such as ourselves, we can help classify your goods and services and determine a unique filing strategy for your business. This includes what classes you should file under and whether you'll be filing a 1A or 1B application, which we'll talk further about in later slides. It's essential to conduct a clearance search prior to applying for the trademark to make sure that the mark is already not registered by another party. And once you've determined that the mark is available, then you can go and file the trademark with the USPTO, which is the United States Patent and Trademark Office. After filing the trademark application, it will be assigned to a trademark examiner who will review it for compliance with trademark laws and regulations. And then the final step would be to await publication and registration, which Brittany will talk further about in some later slides. So the different types of trademarks. A trademark application can be filed either as a standard character mark or for a stylized mark. The main difference between these is the way that the mark is presented. So a standard character mark covers the literal element of a mark, which means it could be a word, multiple words, letters, numbers, and it can be in any configuration, whereas stylized marks are more for like unique designs or symbols or words written in a particular font, configuration, or color. These typically stylized marks are for company logos is what we see the most of. But we advise clients to pursue standard character marks as a first priority in a trademark protection, because this offers you the broadest protection and will cover the name no matter how you decide to change it in the future. If you change the coloring or styling, any differentiation, a standard character mark will offer you the broadest protection. So as I mentioned previously, it's very important to conduct a clearance search before you file for your application. Clearance searches verify that your proposed mark is indeed unique and it's available to register and ultimately used by your business. Clearance searches help avoid potential conflicts and increase the chances of successfully obtaining registration for the mark that you want to apply for. LVLUP Legal offers 4 different types of trademark clearance searches. The first is comprehensive, the second is high level, the third is a knockout search, and then the fourth is a filing only option. And Brittany will go a little bit more in depth on what each of those offer.
Okay, hi everyone. So at LVLUP Legal, we offer the 4 different options for searches and filings. We use a specialized AI software to run all trademark searches for any competitive marks on the USPTO, Google, and all social media channels. For a knockout search, we search your exact mark and make an immediate assessment as to whether there are conflicting marks that would possibly prevent registration. With our high level search, we spend about an additional hour of our time to review in more depth and strategic manner and assess the results, as well as conduct any further research if necessary. And then our full comprehensive search, we spend around 2 to 3 hours of our time to conduct a complete search in the most detailed manner. All of our searches include classifying your goods and services, determining your filing strategy, preparing your application, and continuous monitoring of your application. With the filing only option, there's no search, but includes the last 4 things I just mentioned. As for classifying your goods and services, there are 2 options. When filing your trademark application, it's important to accurately describe your goods and services. So the first option is the TEAS Plus, and this is, with this option, filing your classes is $250 per class, and the USPTO has a manual of goods and services from which we can pick standard templated descriptions. Although they are sufficient descriptions, it does not offer the best and broadest protections. And then we have the TEAS standard application, which is $350 per class. This option allows us to create custom identifications that accurately and specifically describe your goods and services. Both are great options. It just depends on your goods and services and whether more specificity is needed. So yeah. And then we can move on to the filing strategy. So trademark applications can be filed in one of 2 ways, and this really depends on your use. So the first option is a 1A use in commerce. With this, we have to somehow prove that you're currently using your mark in connection with your goods and services. And then we have the 1B intent to use application. And with this application, you basically reserve the right in your trademark before the goods and services are made available. This kind of gives you more time to get your business or your website up and running while protecting your brand in the meantime. And with this, we have time to prove use at a later time. So now I'll talk a little bit more about the registration timeline. Once we file your application awaits assignment to an examining attorney for review. According to the USPTO right now, the current wait time is about 8 to 9 months. But as soon as you file your application, you may begin using the trademark symbol in your mark. Next, we have the evaluation stage. At this stage, the examining attorney checks for any conflicting marks. Hopefully, we avoid any conflicting marks with the trademark search at the beginning of this process. But basically, if there are any conflicting marks, and by conflicting marks, I basically mean that they are similar in appearance or that maybe they're similar in sound. And if they're similar in appearance and sound, maybe they offer related goods and services. So if there are any conflicting marks or there are any other issues, the examining attorney will issue an office action, which we have 3 months to respond to. So that doesn't mean that your application won't continue through. We just have to present our best arguments to say why your application should be registered and why, for example, the marks aren't similar, or why the marks offered or how the goods and service are dissimilar. This stage also includes time to submit proof of use for your application if we submitted a 1B filing basis. Once you make it past the evaluation stage, your mark proceeds to the next stage, which is the publication period, and it's really exciting. The publication period is basically a 30-day period that allows others the opportunity to oppose your mark for registration. So say your mark is similar to someone else's mark, they have time to be like, hey, my mark was here first and we're going to oppose your mark. But if your mark is not opposed, then we progress through to registration finally. And at this point, your brand is officially protected and you receive a certificate of registration from the USPTO. And now you can finally use the R in a circle symbol with your mark.
Okay, so that was a lot of good information, and we're going to be sending these slides out to everyone involved. So I'm going to open it up for questions, but what we're going to do as a next step is we're going to go through the presentation with an example to kind of showcase exactly how what Brittany and Selena went through really works in reality. So and we're going to kind of do it as a live type of, I'll ask them questions, they'll respond back to me, and we'll talk about how it would work. So say you have a company that is delivering flowers. It's a flower delivery company, and it's called Fruit of Flowers. And that's just because of all the colors. I made that up because none of our clients have that, but we do have flower delivery service companies that we work with. So you have a company called Fruit of Flowers. In that company, you have the word Fruit of Flowers that you use on your website, that you use in commerce, and you also have a logo. But with the logo, you have, a picture of flowers, but you are not yet 100% sure on it, and you're not yet using it in commerce. So we're going to go through the process of when and how you would file a standard character mark for that and a stylized. So the first thing you'd want to do is think about, is this a good or a service? Who can respond as to whether they think that Fruit of Flowers is a good or service? I'm going to write exactly what it is. Oh, right. I know it's Monday. People don't want to participate, but oh, there we go. Exactly. So this you would classify as a service. So with the reason you wouldn't want to classify it as a good, because a good is a particular item. For example, a lot of beauty brands we work with will classify their items as a good. So then the next step that you're going to do is you're going to think, okay, are there other competitors in the market under that particular service? And what classes do I want to file under? When you look at competitors, for example, there's actually other level ups in the market, but they're not law firms. So that's a different class. So they're actually permitted and they're able to operate with the word level up associated with their business. So the class is extremely important because you want to make sure that when you're filing a class, that you're looking at the goods and services that Selena and Brittany mentioned. So, there could be various classes, and Brittany, Selena, jump in if I'm not fully, thinking correctly on all the classes. So there's the delivery service, that's one. And I mentioned that you're operating online. So then there's the e-commerce website that you potentially want to protect. What would be a couple other ones? I'm trying to think off the cuff.
So flower delivery, I believe, would be class 39, and then internet sales is class 35. So those would be two classes that we would automatically off the bat go and search for similar variations of that name in those two classes.
Right. And so say that you found a fruit of flowers, but that company is they operate a gardening. They basically have a gardening type of flower that they put in the ground. Now it's still flowers, but would that be an issue? Let's see if the audience can guess if that good would be considered a conflict. It's a tough one, actually. Okay, we have a no. So generally, it would cause confusion among consumers, potentially. So this is kind of a trick question. So it could potentially be in a different class, and that's okay. But it's 100% subjective on the examining attorney that the trademark is assigned to. So after you apply, you put it in a different class, you make sure to potentially do the 350 application to really specify and make sure that it's very different than the one you found the conflict in. And sometimes the examining attorney will find an issue with that. And with that, we have office actions, which we're going to do a separate workshop on, which is a little bit more complicated in terms of, how to respond to that and how to deal with that. This is really just about the filing of a trademark. So what someone in the audience, Gohar, mentioned is the question of whether A, it would cause confusion among consumers, and B, if the examining attorney found that to cause confusion, how are you going to potentially differentiate? And there's a couple other strategies that you can do that. So after the clearance search, you want to make sure that you file in the appropriate classes, and then it's a gorgeous waiting game. So with that, we had talked about the word fruit of flowers, and then potentially the logo. Now, the question is fruit of flowers a standard mark, and the logo, are those two separate trademarks, or are they one? We get that question a lot about whether or not, we can trademark both the name and the logo into one. And, whether or not, if there's a conflict in the standard, can we file in the stylized? There's a couple of different strategies. So say, for example, you found that there is a similar mark in the standard character mark. Sometimes we could recommend that we file in the stylized with the logo, and that could sometimes overcome that. We've had a client that did that. And then also you want to make sure that you're filing in the right appropriate 1A and 1B, depending on whether you're using it in commerce. So as I mentioned, if we're using fruit of flowers on a website and we're actually using it in commerce, that would be a 1A, which we mentioned in the later slide. And then the logo, I mentioned that you have the logo and you're not fully sure. A big question we get is, can we file the logo right now, and can we change it later? What do we think the answer to that is? I'm going to ask the audience again. Can you change a mark once you file it? Oh, good group. Yes. No, you cannot change it. So when I had said that the logo is like kind of there, but not fully there, we would actually recommend do not file your stylized logo until you are pretty much 100% sure that that's the logo that you want. Because once you file it and you pay the filing fees, and it does take up to a year to get registered, You change it, we have to refile the application. There's also different strategies that you can file, whether you do black and white. If you do black and white, that means you can pretty much use any color. If you do color, then you're protecting those colors. Now, one thing you want to remember is that when you're doing a logo mark, you're protecting the logo from being used by another company in the same or similar industry. So for example, we had a company looking to trademark a logo that was almost like a thumbprint in the privacy and like the data privacy type of sector. And that's actually relatively popular. So even if the company has a very different name, that's something that we want to make sure that we protect. We also had another client that was really operates with the image of a lightning bolt. That's also a very popular type of logo. So we want to be really strategic. So that's something you want to think about. Oh, okay, muted. Perfect. So that's kind of stylized. All right. So fruit of flowers. We have a lot of different pricing options, as we mentioned. And how do you decipher whether you go through the four that Brittany mentioned? Fruit of flowers. Now, the word flowers is being used in a flower delivery service. With that being said, it's probably going to have some competitive marks. In that case, we would usually recommend comprehensive or high level. This is because you're operating in a competitive type of, your name is not 100% unique, right? So there's going to be some competition there. That's what you have to think about when you're picking. Now, a good example of a brand that probably could have gone with knockout or filing over is Uber. What the hell is Uber, right? Google. We don't know, those are all made up names that those companies chose to operate with. And because of that, there really probably wasn't anything in the market at the time. So they could go, with knockout or filing only just to make sure that there wasn't anything, but most likely there wouldn't be. So in this respect, we would say comprehensive or high level. And the reason is that the filing fees, as Brittany mentioned, they range from $250 to $350 per class, and they're non-refundable. If you get an office action or find a competitive mark after the fact, in our next one, we'll talk about office actions, but you ended up basically wasting those filing fees if you didn't properly strategize on how you want to file. So it's good to just make sure you know what you're doing and not waste your money in the long term. Proactive versus reactive. So basically, like Brittany and Selena mentioned, this 250 is going to be like based on what the USPTO gives you. Now, if there isn't a flower delivery service type of description, you would want to put it in the 350. You don't want to over narrow it, but you want to make sure it's specific to your business. There's two reasons for that. One, if there is something competitive in the market, if you do get an office action, you could be like, well, ours is different. This is why. And there's stronger arguments. If you go with the standard test, sometimes it limits. On the back end of that, examining attorneys are comfortable with these descriptions. So a lot of times they are okay with this. It just depends on your business. It depends on what kind of, the evaluation of competitivism on that. Another thing that I just thought about, we get questions on is, people want to trademark slogans or different things, but remember, it always has to be with a good or service. So that's something that, you want to be really particular about when you're trademarking, that it has an association with a good or service. So 1A or 1B, I'm going to ask the audience again. For the logo that we're semi-sure on, which I had mentioned, would you file a 1A or a 1B? A 1A is it's actively being used in commerce, and 1B is an intent to use. One B, yeah. Good job, Natalie. The answer is 1B. 1B because you're not currently using the mark in commerce, but if you were finalized it and you were ready to, you can file an intent to use. Now, what's the difference in timeline? The good thing about the intent to use, as we mentioned, the registration process can take up to a year. So you're kind of getting yourself in line you're ahead of a lot of other people who may be thinking about filing that mark. And then it still goes through the registration process. And then in 1 year, or whenever you get the registration, you just have to show something called a specimen, which indicates that it's being used in commerce. And you can also have extensions too. I believe it's up to 3 extensions. And a specimen, that's another question we get. What's a specimen? A specimen is an image of it being used in commerce. So it can't be just a picture of your logo. It has to be being used in commerce, etc., on your website. Say, for example, we've had clients that have a good that they want to, that they've trademarked, but potentially the good is not available for consumers. This is a trick that you can do. You can put it on your website, have it available, but maybe say coming soon, or, you know, sold out, whatever it is, but you can show that it's available if you want to make sure that you're on the timeline, because if you do not answer or respond within the timeline, you sometimes have a chance to extend, but it costs a little money, but it could potentially abandon your mark. So the timelines of trademarks are extremely, extremely important, and you have to stay on top of it. And so there's different ways that you could kind of work with the 1B, 1A, but generally, it's always good to do, you know, 1A, because it's just easier. We get the whole application in. 1B we've dealt with, and then some people are like, oh, we don't have the right specimen. It's a lot of back and forth, but generally the rule of thumb is file. Okay, yeah, and then this is like, we show the timeline. This timeline takes honestly anywhere between 9 months to a year, but the good thing about having the filing is that you have the TM symbol next to your mark. While the day you do this, you put the little TM just to put everyone on notice that I have filed. The R with a circle is registration, and that is like when you've made it. And so if we file fruit of flowers here, we put the little TM there. Regardless of what the examining attorney comes back with, regardless of the situation of the mark, you always get to use the TM once you file. We have clients that use the TM without filing. Don't do that. And so that's kind of the whole period of time. Also, we get questions about, okay, now I filed, what happened? You just wait. If you work with us, we will let you know when you get a response, and we often have your email copied in, so you will get the USPTO correspondence, but you know, your attorney will follow up with you. Just chill, use the TM, operate as you would. Any new trademarks that come in, let us know. Another thing that we do is we police your mark. So there's something called the TMOG, which we can see what other marks have come up that have been filed with the USPTO. So in that case, if something comes up, we also help clients with cease and desist letters to make sure that we police the mark appropriately. So that's kind of the process if you want to go through an example. And again, we're going to share these slides with you guys. For those of you who are looking to file a trademark, you kind of want to know what the process is. That's really what it is. So yeah, Brittany, Selena, anything we want to add?
I think you covered everything. We're ready. If anyone has any questions, we'd be happy to chat.
Yeah, so any questions, we're going to open up the chat box. And then while you guys are asking your questions, we'll kind of talk about some situations that our clients have had confidentiality that we've had to deal with. But we have one. What happens if the USPTO refuses to register a mark? Selena, I'll let you take that one.
Well, in this case, hopefully if your attorneys are doing their job properly, this wouldn't happen, because through the clearance search, when we go and see your mark and compare it, as we previously mentioned, to the types of goods and services that you're offering and the classes that you want to file, and we will let you know if this will happen. Granted, the examiners they do whatever they want, so we can't guarantee 100%, but if you do the search correctly, and we will let you know your likelihood of obtaining that mark. So hopefully that will not happen if you do the whole trademark process correctly.
Another thing I want to add is that once you file, they won't just refuse the mark out of the blue. There's a whole process. You'll get an office action, which your attorneys can try to respond to. I believe it's 60% of trademarks get some type of office action because the USPTO has to justify paying their employees to do their job. And that is something that we've really successfully overcome. A lot of times it just takes a little bit more information to give to the USPTO. Sometimes it takes a lot of more information that we have to give to the USPTO on this, but I think we get 3 different office actions, correct? So you get an initial, a second, and a final. So you have 3 opportunities and you have 6 months to respond in between each of them. And then if at the final you can't get the mark, that is when you get the refusal. But at that point, we can also amend to something called the supplemental registrar, which it's like the second-year version of the USPTO's getting a trademark. And then after, I believe, 5 years, you could potentially amend to get on to, I don't know what the opposite of supplemental is, but the main one.
The principal.
The principal. Brittany, do you want to add anything?
Also, if your mark is refused for, let's say, a conflicting mark, we could check to see if the mark has been in use or not, because we just had a client where there's a mark that their application was cited against their application, and it looked like their mark was not in use for, say, I think it's 5 years. So then you can potentially proceed with a cancellation proceeding to try to cancel the mark that's registered, and then hopefully your mark can get registered. So there are a couple of different ways you can go about a refusal.
Very good question. Any more questions? So I wanted to talk about like kind of those strategies that you were saying, Brittany, about suspension, and how that really works. So, we had a client that they're dead set on their brand name. They've been operating, they want it. Even if we tell them that there is another mark out there, sometimes people really just want to file it and fight it. Now, there's a couple of different things we can do when that happens. One, definitely look and make sure that we're trying to file in a very different class, or just in a very different type of description, making sure that we're using the 350 very narrowly, separating the two. That's the initial thing that we'll do. Doesn't always work, because we will notify a client, like, you're going to get a likelihood of confusion. That's going to happen. It's going to be difficult to overcome. Now, we recently had a client who, we noticed that there was a conflicting mark. So say you notice there's a conflicting mark, but that business has received a final office action. And you're thinking, okay, if they can't overcome this office action, then maybe once we file, that one will be out of the picture. And then we have to perceive if we could potentially get an office action on the one that they did. And you basically want to play chess when it comes to that. You want to basically think, okay, if this is going to happen here, this one's going to be knocked out. Is that going to cause an issue? How are we going to do that? So you want to make sure you know your timeline. But one thing we always recommend is file, because you should file to prevent another business from taking that name, but also it puts you in line. We don't know how long it takes for an examining attorney to get to the trademark to issue a likelihood of confusion. So you just want to make sure that you're in line with that. And then say, for example, you get that likelihood with some other mark, you can also suspend your mark for a period of time. A suspension just basically allows you to be like, okay, we don't want any office actions. We don't want any responses because the 6-month period is not enough time. Let's suspend. We're still in the running. We still have the TM, but it lengthens your timeout. And that only happens if the U.S. examining attorney allows you to do that. Right, Brittany? I'm making sure I'm saying that correctly. So there's different strategies, and that's why it's important to work with an attorney, especially if you have a very common type of name, like different brand names that have really, the words that may make a lot, like if you have a skincare brand with the word glow in it, that's been really popular. You really want to make sure that you strategize. So that's really important. But yeah, so let's see another question. The best way to schedule a consultation. We have
I
our
just
email
provided
there.
a link. Yeah, you can email us, or I just also provided the link in the chat for anyone who's interested.
And just so that everyone knows, we're offering 10% off all of our search options through the month of April. And on our website, we have a description of the different types and the different pricing. So one thing about us is that we really believe in transparent pricing. We know that a lot of people who are on this call are new founders, potentially people who are bootstrapping. So we always try to be very transparent with our pricing. Each of those searches is for each type of mark. So if you want to do a logo and a word, those are going to be separate searches. As we mentioned, they're very different. But we're offering the 10% off. And then even if you, as long as you engage us in April, and even if it goes into May, we will be, offering that 10% off in terms of that. Again, there's our website. Okay, do we have any other additional questions? Okay, so we were thinking about ending early because I know it's a lot of people's lunch hour, but we're going to send an email, like I said, with our information. Again, we're offering 10% off, but any questions that any attendees have on trademarks, this is just the search process. We're going to do a second one next month on office actions. Those can be feel really stressful. If you're getting all the notifications, it can be a lot. So that's going to be a little bit more in-depth for the second step. But any questions, feel free to reach out via email. And thank you guys so much for attending. Okay, great. I'm going to stop sharing.
Thank you.
Thank you all.
Thank
Bye.
you.